Welcome and thank you for standing by. At this time, all participants are in listen-only mode. During the question-and-answer session, please press *1 on your touch-tone phone. Today's conference is being recorded. If anyone has any objections, you may disconnect at this time. I'd like to go ahead and turn today's call over to Janice Wingo, International Trade Administration. You may begin.
Good morning and welcome to today's webinar. Today we're very lucky to have two partners from Haiwen and Partners on the line with us today to talk about trademark licensing. On the line from Vancouver we have Yulin Zhang, and the presenter for today is Mr. He Fan, who is a partner with Haiwen and Partners in Shanghai. Mr. He Fan will be presenting on how to do trademark licensing in China. Mr. He Fan has over 8 years of practice experience, with his specialty being IP protection. He also has experience in foreign direct investment, dispute resolution, and mergers and acquisitions. He's advised Chinese and foreign clients on a large range of IP issues regarding their commercial activities. And he has also represented foreign clients in a number of arbitration and litigation cases in China. So we're very lucky to have his experience, his breadth of experience in presenting on trademark licensing. Lawyer He?
Yeah. Hi, Janice.
You're on.
Hello, may I?
Yes.
Okay, that's good. Yeah. Hello, everyone. This is He Fan from Haiwen and Partners Shanghai office, and I'm doing this presentation with my colleague, Mr. Jerry Zhang Yulin. Actually, my practice area includes IP legal issues in M&A, foreign direct investment, and dispute resolution. It is our pleasure to discuss the IP issues regarding trademark licensing in China with you during this presentation. And as you can see, we have prepared some slides for today's presentation. And actually, when preparing the slides, I think during this 30 minutes presentation, I just want to give you a general overview of trademark licensing under PRC law. And I also want to discuss with you about a very specific issue in cross-border trademark licensing, which is about royalty payment. This issue recently frequently arises in some of the M&A deals and the foreign direct investment cases I'm dealing with, and I just want to share it with you. And actually, the royalty payment issue relates to trademark licensing in China, as well as some of the PRC regulations on foreign exchange conversion and remittance. Okay, that's the brief introduction of myself and the topic today. So if you can turn to page 2 of the slides, you can see that there are 3 issues here that we will discuss. The first one is, as I said, a general overview of trademark licensing in China. The second issue is about the defining requirement for trademark licensing. And the third issue is a specific issue I want to talk about, which is royalty payment issues in cross-border trademark licensing. So let's move to the first issue, which is a general overview of trademark licensing. I think you may turn to page 4 of the slides. Okay. The first issue we want to talk about is the government authority of trademark in China. Actually, in China, the government agency in charge of trademark matters is the State Administration for Industry and Commerce, which we normally call SAIC. This government agency operates directly under the PRC State Council, and it is generally responsible for the registration and the supervision of the business activities of industrial and commercial enterprises. If some of the listeners here do some business in China, you will know that SAIC is also the company registration authority in China, and many enterprises have to deal with SAIC or its local counterpart frequently during the daily operation. And as to the trademark matters, the trademark registration matters are normally handled by the China Trademark Office, which we call Trademark Office or TMO under the SAIC. The Trademark Office examines trademark applications and decides on matters relating to trademark registration, opposition, and licensing issues, etc. The Trademark Office maintains a Trademark Review and Adjudication Board, which sometimes we call TRAB. And TRAB is responsible for things like deciding cancellation requests, reviews of rejected trademark applications, and other appeals of decisions of the Trademark Office. But TRAB does not deal with trademark licensing matters directly. So in this slide, we just talk about China Trademark Office under the State Administration for Industry and Commerce. This is the first issue about government authority. And on this page, you will also see the second issue, which is a definition of licensing. Actually, in this part, I just want to briefly discuss with you about some of the important concepts of trademark licensing under PRC law. The first one is licensing and assignment. And actually, the concept between trademark licensing and the trademark assignment, I think that the major difference is very clear. That is, whether the ownership is transferred. If the ownership is transferred, apparently this is a trademark assignment. But I think apart from that, there are some other very important differences between trademark licensing and the trademark assignment in practice. The first difference is the authority of the Trademark Office in the trademark licensing and the trademark assignment. Actually, assignments of registered trademarks in China must be verified by the Trademark Office, while licensing of a trademark only needs to be filed with the Trademark Office for record. And we will talk about this later. Even if the parties do not file the trademark license with the Trademark Office, the validity of the license agreement will not be affected. In other words, I'm sorry?
Oh, I was just going to interject here, and sometimes people call that a recordal.
Mm-hmm.
Yeah, go ahead.
Sorry.
Okay, may I?
I'm sorry. Mm-hmm.
Okay, thank you. And that's the first difference I want to talk about trademark licensing and assignment. That is the authority of the Trademark Office. And the second difference between licensing and assignment is which party handles the government formalities. In the trademark assignment, it is required that the government formalities to get the verification from the Trademark Office should be handled by the assignee. But in a trademark license, the formalities is required to be handled by the licensor of a license agreement. This is the second major difference. And the third difference in practice is the influence to the other marks of the transferor or the licensor. In a trademark assignment, the party that assigns a registered trademark is usually required to simultaneously assign all other identical or similar registered trademarks covering identical or similar goods or services owned by such a party. This is what is required in the trademark license. But in the this is what is required in the trademark assignment. But in the trademark license, the licensor may only license one mark and keep other similar marks unlicensed. That's the sum of the differences between the trademark license and assignment under PRC law and in practice. And the second issue I want to discuss about the definition of licensing is the registered marks and the registered marks. Actually, in China, there are a lot of trademarks are registered with the Trademark Office, but there are still some unregistered marks, and some of the marks are quite famous, and we call them famous unregistered trademarks. And both these two kinds of marks can be licensed, and the licensor can collect license fee based on either a registered mark or an unregistered mark. But for the unregistered marks, the license agreement cannot be filed with the Trademark Office for record. And as I said, even if the agreement cannot be filed, it is still valid, and the licensor can still collect the license fee. But in a cross-border trademark license arrangement, if the license agreement cannot be filed, which means if the filing record cannot be obtained from the trademark office, there might be some issues regarding royalty collection. We will talk about this in the third part of this presentation. And the third concept I want to discuss about in this part is the Chinese marks and foreign marks. Actually, this means China registered trademarks and foreign registered trademarks. Actually, both these two marks can be licensed, and the parties may sign a license agreement, and it is valid. But the same problem is that the license agreement for foreign registered trademark, for foreign trademark, cannot be filed with the trademark office, and this may cause problems when the foreign licensor collects royalties from the PRC domestic licensee. Okay, this is the what we want to discuss on page 4, government authority and definition of licensing. And now we may turn to page 5, which is the types of trademark licensing. And this issue is actually very interesting too. I mean, in practice, under PRC law, there are three types of trademark licensing. As you can see from the slide, the first type is what we call, in Chinese, we call it 独占性的许可, and in English, it's called exclusive license. It means licensing a trademark to one licensee only, and the licensor itself is prohibited from using the licensed trademark. The second type of trademark license is called what we call sole license. This kind of license in Chinese is called 排他性的许可. It means the trademark licensor licenses the trademark to one licensee only, and the licensor itself may also use the licensed trademark. And the third one, and the third type of trademark licensing is a non-exclusive license. And this non-exclusive license, we just call it 非排他性的 or 非独占性的许可 in Chinese. It means the licensor may license the trademark to one or more licensees, and the licensor itself may also use the licensed trademark. It is important to note that in some English license agreement, in practice, in some English license agreement, it sometimes only say that the license is exclusive and without other descriptions or provisions. And this word, exclusive in Chinese, sometimes is translated as exclusive license, as I might mention in this page of the slide, and sometimes it can be translated as sole license. And as you can see here, different translation may lead to different legal consequence. So it is actually important when drafting a license agreement in English, it is quite important to specify whether the licensor has the right to use the licensed mark or not. Otherwise, the document may be translated as a sole license agreement under PRC law, and this may be, different from the intention of the parties when the parties sign the agreement. So this is what we want to discuss on this page 5, types of trademark licensing. And on page 8, we want to briefly discuss about some PRC law requirement on the quality control in the trademark licensing context. The first requirement is that the licensee should ensure the quality of their goods bearing the licensed trademark. This is required under Article 40 of the trademark law. And usually, according to the trademark law, the licensee should also specify its name and the place, location of the product on which the trademark is used. And as to the obligation of the licensor, it is required that the licensor should supervise the quality of the licensee's goods bearing the licensor's registered trademark. Sometimes in practice, the licensor will ask the licensee to provide documents, some government documents, to prove the quality of the licensee's products, and the licensor may also require that the licensor should be entitled to conduct some regular or irregular inspection on the factory of the licensee, things like that. And the third issue is the use of advertising, promotional, and printed materials subject to standards set by the trademark owner. This is because in practice, some licensors have some trademark policy, and they just impose the trademark policy on the licensee, something like where the trademark should be placed, its color, the font, things like that. This is not a mandatory requirement under the PRC law, and it is usually subject to the parties' agreement in a trademark license contract. And sometimes the licensor may place these standards in the license contract. And the third issue is the warranty of trademark ownership. Actually, this is not a mandatory requirement under PRC law either, but in practice, licensees sometimes requires that the licensor make some sort of warranties. And the major warranties licensees want to see include the first one is the licensor's ownership of the mark. The second one is that the licensor should be obligated to maintain validity of the registered trademark. As you know, the validity term of a China registered trademark is 10 years, and at the time of expiration, the licensor is usually required to apply to the trademark office to renew the mark. And the third warranty that a trademark licensee may want to get from the licensor is the licensor's obligation to defend the mark in case of a trademark infringement claim. Okay, that is the quality control issue we want to talk about on page 6. Then we can move to the second issue we want to talk about, which is the filing requirement for trademark licensing. I think we can turn to page 8. Okay. The first issue is a filing requirement. As we discussed just now, the licensor is required to file a copy of the license agreement with the trademark office for record. And the time period to make the filing is 3 months upon signing the license agreement. It is provided under both the trademark law and the implementation rules of the trademark law that the parties should file the trademark license agreement with the trademark office. But in practice, even if the parties do not file the agreement, as I said, the validity of the agreement is not affected. It can be enforced by the People's Court. So this should be noted. So this is the second issue here. Validity of a license agreement is not subject to the filing. But it should be further noted that in a cross-border license, if the parties do not file the license agreement with the China Trademark Office for record, the parties will not be able to get a filing record issued by the China Trademark Office. If the parties cannot get the filing record, the PRC domestic licensee will not be able to make the foreign exchange payment to the foreign licensor. So if the filing cannot be made in a cross-border license, there will be foreign exchange payment issue, and the foreign licensor may not be able to get a royalty payment. And this is relatively very important in a cross-border trademark license. Okay, then we can come to page 9, which is filing procedure. Actually, the filing procedure is quite simple. The trademark licensor applies to the trademark office for filing the trademark license agreement. And usually the trademark licensor, if it is a foreign company, it makes the filing through a qualified trademark agent. And the trademark agent will prepare a complete set of the application documents and submit them to the trademark office. And after the trademark office accepts and examines the documents, it will review and decide whether the documents meet the filing requirement. If the document does not meet the filing requirement, it will instruct the filing agent or the trademark licensor to make some supplement or correct the filing documents. If the documents are fine or okay, then the trademark office will take the documents and issue the filing record. That is the normal filing procedure to file a trademark license agreement. And the filing application fee is according to the trademark office's publication. It's RMB 300. It's not very expensive. Okay, this is about the trademark filing. I think we can turn to page 10, which is royalty payment issues in cross-border trademark licensing. To discuss about the trademark filing issue, there are two extra issues that the parties should be aware of. The first one is that if a trademark is owned by two or more entities or individuals, which means that the trademark is co-owned, the license agreement should be signed by all of the owners. Otherwise, the trademark office will not accept the filing. Because the trademark office wants to make sure that all the owners of a trademark agrees to license the trademark to a specific licensee. And the second issue that you should be aware of is that when applying for a trademark license agreement filing, original of the license agreement is sometimes required by the trademark office. So when you sign the agreement, you may need to produce an extra original contract for the filing purpose. Okay. The last issue, also the very specific issue we want to discuss about, is the royalty payment issues in cross-border trademark licensing. As you know, foreign exchange conversion and remittance is regulated in China. The government authority of the foreign exchange conversion and remittance is the State Administration of Foreign Exchange, or we call SAFE, SAFE in China. When a PRC domestic entity pays royalties, trademark license fees to the licensor outside of China, the licensee shall first purchase foreign currency from a qualified PRC bank and then ask the bank to do the money remittance. The bank will ask the applicant to provide some documents, and among which include the filing record of the license agreement. That is why we raised the filing issue as a specific issue in this presentation. I think we can move to the next page, which is page 11. In page 11, we are discussing two issues here. The first is registration before licensing. As we discussed just now, the trademark office only accepts filing of a license agreement under which the trademark to be licensed is a China registered trademark. In other words, foreign trademarks or used but unregistered trademarks, although they can be licensed, but if you produce a license agreement to the trademark office for filing purpose, the trademark office will not accept such a filing. In other words, only China registered trademarks the license agreement of China registered trademarks can be filed with the trademark office, and other marks cannot be filed because the trademark office will not accept the filing. So this comes out an issue of foreign trademarks, whether used or unregistered, or whether used or registered but not registered in China. It can be licensed to Chinese entities, but the foreign offshore licensors cannot collect royalties because the license agreement cannot be filed with the trademark office for record. So the solution we propose is that for filing registration of trademarks in China, it should be a prior strategy for foreign clients and companies to have the trademark registered in China first. Otherwise, there will be an issue of royalty collection. And as to the remittance of royalties by the Chinese licensee, the remittance of royalties must be handled by a designated foreign exchange bank. And when the bank handles the royalty payment, the bank usually needs to examine a number of application documents, and I think we can move to page 12. And this kind of documents normally include a written application of the parties, the license agreement, the invoice or payment notice, and number 4 is the filing record issued by the trademark office. And this is really very important. And in practice, some of our clients try to discuss with the bank and asked the bank to waive the requirement on the filing record. But the banks are quite insistent, and they need to see this document. Otherwise, they will not do the money conversion and the money remittance. So this is one of the most important documents in a remittance of royalties by the Chinese licensee. And the last important document is tax payment receipt. And this is about the royalty payment issues in cross-border trademark licensing. I think I have completed the presentation now. And Janice, I think we can move to the Q&A part. Thank you for listening.
Thank you, Lawyer He. Julie, can you explain to people how they can ask a question?
Thank you. We will now begin the question-and-answer session. If you'd like to ask a question over the phone, please press *1. Please unmute your phone and record your name clearly when prompted. Your name is required to introduce your question. Again, if you would like to ask a question over the phone, please press *1. To withdraw your question, press *2. One moment, please, for the first question.
Lawyer He, can I just ask a question about clarification? When you file your trademark license for the record with the trademark office in Beijing, is there any kind of substantive examination of that document, or is it just filed for the record?
Yeah, it's just filed for the record. I understand the procedural. It is just quite procedural in nature.
What would you say to companies who often have their recordal kicked back at them and told them to redo it again? What would you say to those companies?
Well, actually, when you are filing some application to the trademark office, sometimes they kick back the documents because, for example, they want you to submit 5 application documents, including the trademark certificate, but you did not submit this. So they will ask the applicant to make some supplemental filings.
Sometimes they kick back the document and do not explain why.
Oh, no. Actually, when you are doing this with the trademark agent, they will tell the agent that what kind of document is missing and you should supplement. But for some material incompliance, for example, the parties submit a license agreement for record, but the trademark under the license is not a China-registered mark, then the trademark office will kick back the document and tell you that they cannot accept this kind of application.
What about when you file, after you filed with the trademark office in Beijing and you file with the local SAIC, is there any substantive examination by the local officials of the document?
No, this kind of applications can only be filed with the trademark office in Beijing. The local AICs will not accept this kind of trademark license application.
Don't you file the recordal in 2 places, first with SAIC and then with the local AIC?
No, you just go to the trademark office directly. I mean, the trademark office in Beijing directly.
Right now, I show no questions over the phone. As a reminder, if you'd like to ask a question over the phone, please press *1. One moment to see if we have any questions over the phone. And I'm showing no questions over the phone.
Well, it's very late in Shanghai, and we do thank Lawyer He for staying up so late to give us this presentation. For anybody who's listening to the audio recording, Lawyer He said he would be willing to take questions, and his email is hefan@hiwen, HAWEN-LAW.com. Lawyer He said he would be happy to take questions on trademark matters. Also, this presentation is being recorded and will be posted to the stopfakes.gov website. I'd like to thank Lawyer He again and remind the listeners that next month we have a presentation on enforcement fundamentals for your IP in China.
Okay, thank you.
Thank you, Lawyer He. Thank you, Yulin.
It's my pleasure, ma'am.
Thank you so much for participating in today's conference call. You may disconnect your lines at this time. Thank you and have a great day.